Thank you, everyone. Please be seated. We have one final hearing this morning. Valdez versus West Des Moines Community Schools. It's my understanding Ms. Flynn will be arguing. You may begin.
May it please the court, counsel, my name is Megan Flynn, and along with my distinguished co-counsel, Angela Campbell, I represent plaintiff Davina Valdez. Plaintiff raised a number of issues in her appeal seeking a new trial in this case, and I'm prepared to speak to any issues raised, and I welcome questions in any order. We are here today because Davina Valdez, who is Black and with Hispanic heritage, was brave enough to stand up for children she taught and loved and to challenge blatant harassment of herself and others within her workplace. At the trial, at Ms. Valdez's jury trial, the one sole Black juror on the panel was struck. A new trial is warranted under existing Batson precedent and the 14th Amendment's promise of equal protection, and I can describe exactly how and why that is. However, more than that, and more interesting than that, this case presents the record, I think, which this court can and should choose to address a lingering problem within the trial system, which has potential to make irrelevant any other advances that this court has put into place, including in the fair cross-section cases. That lingering problem, and I didn't hear these words mentioned yet today, is implicit bias in jury selection and the use of peremptory strikes. While that may be a problem that this court chooses to address outside the purview of today's case through rulemaking or other similar efforts that are afoot nationwide, there is a solution which can work directly in this case, and it's a simple one. Why is it important to go further and address state law and the state constitution? As demonstrated by the facts of this case and the all-white jury that decided Ms. Valdez's race discrimination case, in the end, the Batson procedure is flawed. It's flawed because it places the primary burden on the plaintiff or the person resisting the strike to prove that the strike is discriminatory on what can only be an insufficient record. Without the opportunity to collect evidence, a party resisting a strike based on Batson is essentially required to prove discriminatory intent of the striking attorney. It also requires the judge, in order to sustain a Batson challenge, to either accuse the striking attorney of lying or of discrimination, a task which no judge undertakes lightly. In the background, of course, there's implicit bias, the biases we all hold, but that we don't know of. That's the whole concept, that they're implicit. We don't know we hold these biases. These can affect the questioning of potential jurors. They can affect all of our perceptions, including the trial judge's perceptions of the answers. In sum, the default under Batson is to opt out of fairness and to opt in favor of what may be a racist strike. Why are we not opting in favor of fairness instead, especially when we're dealing with peremptory strikes?
If you were going to ask us to change Batson, or if you want us to change Batson, what exactly would you change about it?
We have suggested a change that probably comes into play in the third step of the analysis, where proof of pretext is required. We're suggesting that the evidence be viewed in the light most favorable to the party resisting the strike, just to offer something to tip the scales and not have the burden weighing so heavily on the party resisting the strike, especially when we may be dealing with peremptory strikes, like as in this case, that involve things of a more subjective nature. And what could come into play in that third step analysis, where the evidence is viewed in the light most favorable to the party resisting the strike, is the totality of the circumstances.
Do that under the Iowa Constitution?
Explicitly under the Iowa Constitution.
Of the Iowa Constitution.
We had raised equal protection, right to a fair jury trial.
Case adopts Batson under the Iowa Constitution?
I'm not sure that it has, but I think that this court could choose to do so.
We haven't adopted Batson under the Iowa Constitution what would be the basis for adopting it under fair trial rights if the U.S. Supreme Court in Holland has said this is an equal protection issue?
I believe it is an equal protection issue, and that this court can do it under the state constitution.
Equal protection issue, we have a laws uniform clause, not an equal protection clause. So should that make a difference in whether or not we should adopt Batson under the state constitution, given that the text says it deals with laws and the uniform application of law versus discriminatory animus at the peremptory strike stage?
I believe that it shouldn't, that this court could use that provision to adopt analysis similar to Batson, and the right to a fair jury trial is also incorporated, and all of the U.S. constitutional case law discusses the fair right of a jury trial.
I mean, is that, I thought Holland versus Illinois specifically rejected that argument and said Batson has nothing to do with the fair trial right, the right to an impartial jury. It's divorced from fair cross-section. It is purely an equal protection right where a party has third-party standing to assert the rights of the juror. Isn't that what Holland says?
Well, I believe that this state has the authority to ensure a fair trial process under the Constitution, and one way to do that is to use the existing Batson analysis and strengthen it, but there are other ways. Other commentators have advocated for getting rid of peremptory strikes altogether, reducing the number of peremptory strikes, changing the analysis used.
I do understand that, and I'm not trying to beat you up on it, but you want us to craft a new rule, and I think before we do that, we should know under what constitutional provision you think the rule should originate, because that matters in terms of the scope of the rule and how it would be applied, and what's the constitutional rationale, because that matters. So in Holland, the defendant raises this exact argument, and the court explicitly says a prohibition upon the exclusion of cognizable groups through peremptory challenges has no conceivable basis in the text of the Sixth Amendment, is without support in any of our prior decisions, and would undermine, rather than further, the constitutional guarantee of an impartial jury. So if we're starting at trial rights, the Supreme Court's made clear, like, this is not the place to do it in terms of peremptories.
And I suppose, as I understand your questions, you may be questioning whether there is a basis under the Iowa Constitution to do it. I certainly read the Veal opinion and Justice Appel's concurrence as providing authority that it could be done. We cited a few different constitutional provisions in our briefing, and it's our position that the Iowa Constitution is strong enough to do this, to strengthen Batson, to use Batson and go from there, to get rid of Batson, to get rid of peremptory strikes, in an effort to make sure that under color of state law, we're providing fair jury trials, a fair process, free of race discrimination. But we think that if necessary, we can get a new trial on the strike in this case, also under existing precedent. We've argued and cited a case, State versus Marlowe, an opinion of the Supreme Court of Missouri, authored by then Chief Justice Dwayne Benton, who now sits as a judge on the Eighth Circuit Court of Appeals. Marlowe and the authorities it cites presents a roadmap under existing Batson case law for effectively protecting against racially motivated strikes in situations like the present case. The facts are analogous. It also mirrors some of the reasoning given in the Flowers versus Mississippi case that show pretext, so that reasons given for a strike are not credible, that there's bias in the questioning, that the main reason relied on, in this case, lack of rapport, is subjective, that no similar white juror was stricken for the same reason that the black juror was stricken, that there were no questions on the reasons for the strike. So in this case, one of the reasons provided for the strike of juror 13 was that he was a management level employee with no complaints, but that wasn't followed up on consistently in the jury pool. It wasn't even followed up on with him. So that also can provide evidence of pretext. So we argue that if this court were to follow Marlowe and the Supreme Court precedent, Flowers versus Mississippi, et cetera, that it could also get to a new trial. But we're arguing for more because it's just not enough. The simple fact that we have put so much burden on the party resisting the strike to essentially prove a mini discrimination case, because the standard is very similar, right? It's the burden shifting analysis, but without the opportunity to get evidence. And how really are you supposed to get evidence of the intent of the striking attorney? And then you have, again, that deference to judges and attorneys who practice together frequently.
Explaining why, tell me how that would work, then how would you change step 3 if you were able to find a way to do that under Iowa law?
What we suggested was just, again, viewing the evidence all in the light most favorable to the party resisting the strike.
So in this case where you've got some, like the management example was, or reason was kind of shown to be not treated the same, and so appears to be somewhat pretextual, but maybe, and then what do you do with things like rapport that is subjective? Are you saying that if it's subjective, it can't be considered at all? How would you weigh those things up?
And so I think that at that point, it should be left to the trial judge to take all of those things together. And it would be on a case-by-case basis. The method of questioning.
Well, in this case, I think the district court judge made a really good record of, he was very careful about how he went through, and especially with respect to rapport. I think he made a comment, you're not going to see this on the record, but I saw it as I'm sitting here. So if you're going to leave that to the district court discretion, then what are we looking at on review?
Well, I think that we would have to still grant a new trial because he did not have the benefit of that standard. He did go into quite a bit of length on the strength of the prima facie case in this matter, and that he didn't, as jury selection was happening, notice the reason for the strike, and a lot of times he does. He knows why the strike is being made, and I actually think that we could have come out with a different result, but we wouldn't know, so I do think it would have to go back down. But I wouldn't say that would be wrong, leaving it to the trial judge, if that's the determination he made in this case, with the benefit of tipping the scales in favor of the party resisting the strike.
The guidance that we're giving the district court then is, under what you're asking for is to weigh the evidence, or when you say evidence, weigh the factors, is that what you mean, in the light more favorable to, or most favorable to the party challenging the strike? Any additional guidance we would give?
No, I mean, I think drawing in the totality of the circumstances, but no, and it's, it's a workable standard that the courts use frequently in other contexts, right? Motions for new trial and motions for summary judgment. So I feel like that familiarity, and again, what they would be considering is the arguments for the strike, the arguments against those arguments for the strike. So it is, you're right, it's not really evidence, but it's that colloquy, and they would be evaluating it, and it's not perfect, but.
But you said tipping the scale or viewing the light most favorable to the challenge. Is that effectively assuming that there's a racial motive?
I don't think so. I think that when you're dealing with implicit bias, it's simply giving parties a fair process, also acknowledging the accelerated nature of a Batson hearing and the fact that it isn't a hearing based on evidence. And I mean, we have to more or less place the burden somewhere. And right now it's resting very heavily with the party resisting the strike, and actually pretty heavily with the trial court in their decision, because they're going to be asked, essentially, is this a racist strike or not? That's a big burden to carry. And you ask yourself, what's the harm on either side? The harm on the side of seating juror number 13 in this case, what does that harm? A management level employee? I mean, it definitely may affect the case for both sides, but it doesn't condone racism.
Case.
I'm sorry, I'm running out of time, may I answer?
This juror.
Well, prior precedent of the United States Supreme Court and all the authorities cited in it tell us that it would have potentially given our client a much better chance to have a jury member of the same race on the jury. We can't know, though. We can't know for sure.
Sorry.
Our plaintiff, it would have given her a better chance of prevailing to have somebody of the same race on the jury.
That this juror would have given your side a better chance to win. Why isn't that in and of itself a permissible grounds for excluding the juror?
I think that it could give her a better chance to win. I didn't say that it would give her a better chance to win. And
Of Batson is the actual jurors that sit on the case don't affect the decision-making process. It doesn't change the result. And I think what you're saying, and what I think everybody knows is true, is that the jurors do matter. And if the jurors do matter, then why isn't that itself a race-neutral ground for excluding somebody?
I think, to me, it kind of turns the analysis backwards. It's something that could help her and that otherwise would have happened, except that the juror was stricken because of his race. And I think what we're trying to avoid is having people being stricken solely for their race, because that undermines the entire system.
Lawyer justify that to the client to say, I knowingly allowed a juror to sit on this case that's unfavorable to your position and makes it more likely that you will lose, and in this case, a civil context, have potentially millions of dollars of liability. That to me seems to be a perfectly reasonable, rational, race-neutral explanation for excluding this juror.
But except that the reason is because of the race. That's how I see it, at least. I mean, it's the reason is based on the juror's race, and I think that good lawyers will do that, and they will design their questioning in order to do that if the current system exists and persists. And I think that's why it has to change, because they need to have something stopping that inclination, or it very well will happen. And I think it still is based on race. I'm sorry, I've taken more time. Thank you.
Thank you, Your Honor. May it please the court, counsel. My name is David Bauer. I have the privilege here of representing the defendants in the underlying action, the West Des Moines Community Schools, and one of its teachers, Desiree Johnson. My intention today was to start with talking about the second set of issues in this case, which relate to the claims against Ms. Johnson and the directed verdict that was entered. But since we didn't get to those issues with Ms. Flynn, I'll start and go in the same order on addressing the Batson issue that's been discussed this morning. As your honors are aware, the Batson sets forth the three-part factor test, if you will. Prima facie case, was there a racially neutral reason or reasons for the strike? And then the court's evaluation then of whether there was in fact purposeful discrimination with the strike. And as our precedent shows, those inquiries largely will turn on credibility, both of the lawyers, of the panel members on the jury, et cetera, because the trial judge is there to see. And the district court's findings in this regard should be given great deference. Here, one of the arguments we made to the district court, and Justice May, I think your last question may have hinted at this, is we have a prima facie standard in the Batson framework, whatever one thinks of that. And that certainly, if anything, means more than coming forward and saying there was an African-American on my jury and you struck them.
More than that, though, at least in my view. I mean, you know, when you are going to strike the only African-American juror, it's a management person. That, you know, what's wrong with asking for a race-neutral explanation? And I have to say my evaluation of the case is I'm not all that impressed with the response that your colleague gave to the judge when asked for a race-neutral explanation, but I'm pretty impressed with the district court's ruling. I kind of second Justice Oxley's view that it seems pretty thorough and pretty convincing. And so what do I do with that?
First point, does it take much more than that to get over the prima facie case? Maybe an academic question, because I think it's fair to just move to the merits here. And as Your Honor indicated, at the time of the Batson challenge at trial counsel articulated the reasons that she had in her mind when making the strike. And the first, which, as you indicated, Justice Mansfield, the district court noted, was there was some concern for anybody who's represented a defendant, particularly in a civil case. One of the questions you almost always ask is, hey, somebody filed a lawsuit, we're here in court taking a week of your time. Does anybody think there's something to this just because of that? And I think many, perhaps most defense counsel, if they get an affirmative response to that, might have some concern. And that was really the first thing that trial counsel pointed out was the juror's response to that question. But then also, as I think Judge Farrell clarified, there was communication issue and what we would generally call rapport issues that trial counsel observed. And I think the trial judge indicated that in his ruling, and I think that's also reflected in what we observed on the record. The final point, which I don't think Judge Farrell thought as much of, is trial counsel had some concerns. I think she referred to this potential juror as a wild card. And part of that was he had been in management for a period of time and seemed to have avoided issues with employees complaining about him. Whatever the merits of that, that was part of the decision-making process here as well. And as all of you know, particularly in civil trials, when you're getting down to exercising those 4 strikes, sometimes there are cases where you know you want to get rid of one person and the rest is kind of a crapshoot. Sometimes it's all 4 that you're just not really sure. And
Aimed the Batson inquiry, and we told the trial judges to just ask this: would the trial lawyer have done the same thing to the same lawyer, to the same potential juror, if they had been white? What if we just got to that issue? That seems to me sort of the heart of the question, right?
it's interesting thinking about how the standard's framed, and that would be more direct. But I think, and it may have been you, Justice Mansfield, who referenced, doesn't the Batson standard already give the tools in the toolbox to the trial judge? I think that very inquiry that you're talking about would be a part of that third step of the analysis as it's currently applied. That would be my sense. And so, our position would be that the standard as it exists, as this court affirmed in Veal, doesn't need to be changed. It doesn't need to go to a for-cause type standard, which I think is more what you're suggesting.
So in this case, you mentioned that one of the bases was the juror's response about being a manager but not ever having any complaints, and therefore your colleagues seem to think that made him a wild card. And I think the district court kind of rejected that because there were other managers who similarly didn't have complaints that were left on, and then there were strikes used against people who were not managers at all. And so what do we do at step 3 if you've got if what we're looking for is whether or not, especially, to some extent, maybe this is a good test case because it did seem that there was nothing particular about any of the jurors that, required a strike or would, give concern to any party. And so then when we're looking at that third step of pretext, is it, what's the standard that we do there? Is there room for saying if there's an allowable reason, but then also a disallowed reason, a discriminatory reason? If what we're looking for is whether or not it was discriminatory, why shouldn't we change, or should we consider changing this burden there at step 3 and saying if there's any improper reason, then the challenge is successful?
It's an excellent question. I don't think that the standard needs to be changed. The inquiry is ultimately the same, at the end of the day, was the strike done with purposeful discrimination? Yeah, I hadn't thought through the analysis the way you're posing it, but I think the way it's already applied was the impermissible reason a substantial motivating factor in the strike? And I think that's more or less.
Is there something different? I mean, we seem to have taken that from the McDonald Douglas test, and I think, because we're here in a civil case, you might be more familiar with that even than criminal attorneys might be. But if what we're looking for is it a discriminatory action in an employment context, maybe, if it's if the justified reason, so like I would have done it anyway, defense would have worked. Makes sense there, but if you've got 2 reasons and one of them a district court judge finds to be discriminatory, why wouldn't we err then on saying, well, if any reason was discriminatory, then you violated equal protection?
Applying the same decision context, if you will, to the employment standard. Well, I think at the end of the day, again, and I may be repeating myself, first of all, that may require a finding by the trial court that a reason was, in fact, discriminatory. That's a different question than whether, as in this case, Judge Farrell, I think his language was he found counsel's concern about this juror's management experience to be less convincing. That's sometimes going to be the case. There's a lot of things that go through lawyers' minds as they're evaluating a juror. But in response to your question, my view is the standard as it's applied currently gives the tools to the judge to make this call already within the motivating.
Reasons that can almost be a proxy for race. So you talk about rapport. I mean, one thing we talked earlier about Black Lives Matter in the courtroom. One thing beneficial that movement called to mind is that often people who are white like me aren't seeing things that people who belong to, or people of color see. And so if someone says, well, I don't have a rapport with this prospective juror, well, maybe I'm more likely to have a rapport with someone who is of the same race. I mean, that could be a proxy for racial discrimination. What do you do about that?
A great question and a very difficult question. And we acknowledge, and I think a lot of the published cases that deal with the problems of strikes based on race address general concepts of rapport, because it is something that's easy in some contexts to fake, if you will.
I wasn't a very good trial lawyer, so I hated voir dire, and I didn't think I had a good rapport with anybody. But I mean, you get where I'm trying to go, yeah.
I think, how do you handle that in the abstract? It's a difficult question as it relates to this case. We provided citations from the voir dire process. There was concern, in particular, from this juror in response to a question from trial counsel that he didn't understand the question, and if she just asked it better, he would have understood it. There was also, as Judge Farrell noted, there were things that were not observable on the transcript here, where even the trial judge noted there was a lack of connection. I think probably if you had a challenge like this where all we're talking about is rapport, if I were the lawyer, I would want a third party to verify that, yeah, there were some connectivity issues going on.
Because, there's this notion of turning on the charm and maybe turning off the charm, right? And so, I mean, some of this sort of comes back to the peremptory strike issue more globally, if I identify someone that I don't want on that jury, can I try to turn off the charm to try to then have a lack of rapport with that person? And then the district court sees it. Of course, we can't really see it. Although I do agree that just in kind of reading that cold transcript, well, if you would have asked that question differently, I might have understood it. That did sort of strike me as, that does not seem like kind of a warm comment to have made back. How do we deal with that as a court at this level, where the district court judge says, I saw it, I get that that's not really going to be something that's going to be in the record for the people in this building to deal with. How do we address that?
Obviously a difficult question. It really is, because you're not there. And so, my comment on that question would be that, again, these things need to be clearly articulated when a challenge is raised. If the judge sees an issue, the lawyer needs to identify specifically what the challenges were. I don't think it's generally enough to, probably in a lot of situations, to just say, I didn't have good rapport. I think it needs to be articulated a little bit more clearly.
When I was picking juries, if I said someone's name wrong, if I called Mrs. Jones Mrs. Smith, I struck her, right? Because I didn't want her thinking the whole time he didn't even get my name right. And so, I get that there's kind of a lot that goes on, that you feel like it might matter, or in this case, as you're, as you talked about earlier, this issue of we'd kind of already used all of our strikes, and so, maybe it wasn't the most important person that we wanted off. It's still a strike that we had, and we didn't want to not use it.
I think globally, the issues you have identified relate to human interaction and language and nonverbal expression. Good lawyers are going to know how to take advantage of that if they want to do that.
Please finish that question. I do want to hear what you were going to say about the claim against Ms. Johnson individually. And the yellow light has not been going off earlier, so I'm not sure where you are in your time.
Yeah. So I think, Justice McDermott, there's only so much that one can do to root out human intentions and motives. My own view is the standard that we have now puts a lot of discretion in the trial courts to exercise in really rooting out and looking at these issues. To address the specific issues you're talking about may require a reevaluation of how we do this, but I'm not sure that there's a better solution than what we currently have. Justice Oxley, I'll just address briefly, if I can, we'll call it the secondary issue or set of issues here related to two claims asserted directly against the individually named defendant, Desiree Johnson, one under the Iowa Civil Rights Act, and then also under a claim of tortious discharge wrongful discharge in violation of public policy. The issue that has been presented that respectfully we think now is a good time for the court to clarify is exactly what the Rumsey holding means for hostile work environment claims. Here, of course, the trial judge directed verdict on both of these claims, and then we had Rumsey come down in the interim. He made an effort to apply Rumsey then in, I see I'm expired, Justice Christensen. May I continue? Sure. Okay, thank you. Judge Farrell then made an effort to address Rumsey in his ruling post-trial. But as your honors are well aware, the standards set forth in Rumsey, which related in that case to essentially wrongful termination, discriminatory termination. An individual has to be personally involved in and have the ability to effectuate the adverse employment action. Well, how do we apply that here to a claim where it's alleged that this was coworker to coworker harassment? And the position, as we've set forth in our brief in detail, that we maintain is the hostile work environment is, by definition, something maintained by the employer itself. And so to suggest that a coworker, as is the case with a public school teacher here, somehow has the ability to effectuate a hostile work environment.
That a coworker could never effectuate a hostile environment if if someone up the chain didn't know about it, or just as applied here?
That's a general proposition. It's certainly the case here. But the argument within even the Rumsey standard is, if I'm low on the totem pole and getting picked on by other people low on the totem pole, and my employer doesn't know about it, the theory would be that my coworkers can be sued under the statute for creating a hostile work environment. And
Civil Rights Act does say any person. So how do you respond to that?
relates to who then discriminates in employment. So the question is, I think, when does the discrimination occur? Yet under this standard, our position would be it's when a hostile work environment is being maintained by the employer. And
Perceive that to be that the employer is liable when the employer doesn't correct what is a hostile work environment, which means that it's conceivable, I think, that an employee could create a hostile work environment and that person could be liable. I guess I don't know why that couldn't be the case.
that really is the question. I think, in the past, we've had this kind of clumsy distinction between supervisory and non-supervisory, and the court, I think, adeptly moved past that. I could certainly imagine scenarios, Justice McDonald, where the individual alleged to be engaging in the conduct at issue, creating the hostile work environment, may be individually liable under some set of circumstances. But generally, particularly with the rank and file, at least as we understand the law, the work environment, a hostile work environment is not actionable unless and until the employer knew or should have known and has failed to remedy. And so your question is, well, didn't it exist before that? It's just a separate box for the employer. And I think our position would be, no, it is ultimately still the employer's responsibility. They are the custodians, if you will, of the workplace.
We disagree with that view. The basis for directed verdict here was a legal one, that the coworker just couldn't be liable as a matter of law. So we really don't know anything about whether the conduct here would be sufficient to be actionable in and of itself. What does that mean in terms of remedy as applied to this case?
The coworker harassment claim was submitted against the employer, and the jury found in the employer's favor. That, of course, added the element that the employer knew or should have known. So I guess we don't know specifically. I think Judge Farrell did a good job of going back through the actual conduct that was being alleged here, even in light of Rumsey, and concluding ultimately, although he didn't state this expressly, that her claim fails as a matter of law regardless. I believe he described it as not a strong case to begin with. I'm well over, Justice Christensen, so unless there are further questions, I'll sit down.
Moving towards the mic, so you can sit down. Again, Ms. Flynn.
We just left off. Is a defense verdict for the employer fatal to the claim against the individual teacher? Why not?
We have, for a long time, had separate instructions for supervisors versus coworkers in the current Iowa jury instructions that don't place that onus of knowledge anywhere in the instruction for supervisors. And the Civil Rights Act is key to any person. We have seen that play out in the aiding and abetting and the retaliation. There is individual liability that is not dependent upon the employer. For parties like Desiree Johnson, the really tough question is, where is the line? What types of...
Rumsey, we were applying the Iowa Civil Rights Act and the very specific language of any person. Hostile work environment is not expressly included in the Iowa Civil Rights Act, and as we said in Hoskenhoff, we kind of adopted that from Title VII. Does that? But we still recognize it as an ICRA type claim. So does that play in at all in how a hostile work environment would fit under the Rumsey context?
way it fits is that it has been deemed a form of discrimination, which is explicitly mentioned in Chapter 216. It has been deemed an adverse action. That's in the federal case law, and this court often looks to the federal case law. So thereby, it is part of the act. It's simply another type of adverse action for which an individual can become liable.
Different, aren't they? It's not just, hostile environment doesn't just replace adverse act within when you're doing the elements, does it?
The elements are distinct from a discrimination claim, if that's what you're asking, but it is a form of adverse action that has been considered a form of discrimination, which is sort of a complicated answer, and I don't know if that quite answers it, but
On to counsel's argument, I think if I understand it right, is that conceptually, hostile work environment is something that can only be done at the employer level because it only becomes actionable when the employer fails to respond. And while the coworker conduct may give rise to liability, it just conceptually it doesn't fit. So what is your response to that?
employer is made up of people. And so what we're really looking for is who within the organization is going to be in the right position where knowledge can be imputed. And I think that's what happens with supervisors by title. There hasn't really been any, if you go back to Vivian versus Madsen, there hasn't really been any fight about that recently. And what we're looking at is the level of authority placed upon this person or that they've undertaken.
Ask it differently. So there has to be an adverse employment action for there to be liability, correct? So in a termination case or a demotion case, we understand clearly what the adverse employment action is. In harassment, is the adverse employment action the actual act of harassment, or is it the employer's failure to do something when made aware of it? And if it's the former, then I could see how you'd have personal liability, but if it's the latter, I don't see the case for it. So how would you respond to that?
Act of harassment, and that ties into the constructive discharge, but it's separate. And the instructions on harassment, it's a significant barrier. You're talking about a severe or pervasive conduct. So we are arguing that the creation of this environment is sufficient in and of itself as an adverse action, which can rest upon an individual. I think it's going to be more rare that an individual is able to create that environment.
Actually gets to, I think, what we're kind of chewing over here, which is, you know, if you don't have the adverse work environment created by, or if there isn't an adverse work environment attributable by to the employer, how would you be able to sue an individual for that same situation? That's really the problem, isn't it?
I think that if the individual was able to, I think that under agency, you are going to be able to sue the employer. I mean, aren't you? I mean, even though the liability may be separate, it depends on how you're characterizing the employer. But I think that it's the conduct of that person.
A bit more with you. So, there's a line of cases that say a stray remark is not enough to constitute actionable harassment, right? So let's assume you have one employee who makes one remark. We would say that employee could not be liable for her hostile work environment, right?
So far.
Another employee the next day says one remark. That person could not be liable.
On the remark, but I'm seeing where you're going with this.
Then can engage in an act that may not give rise to liability under hostile work environment law as we see it. But collectively, the employer's failure to do something about it could be a problem, right? If 20 different employees say one thing one time, that may be a problem for the employer, but not necessarily for the individual employees. Maybe.
Employee who undertakes all of the acts themselves? And is there an opening there because of the any person language and because of that person's position and authority? And likely it will be parallel with the employer and not divorced from it. I'm sorry, I've exceeded my time. Thank you.
Oops, I turned my page here. The case of Valdez versus West Des Moines Community Schools is hereby submitted, and the court will be adjourned for the morning.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.